Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. We hold this community conference call every other Thursday. The posted questions are answered first, and within them, the questions that I have marked as frequently asked questions are answered the very first. After answering each question, I will invite any follow-up questions on what I have discussed. If you have any new questions, you must wait till the end, please. And if time permits, I will answer new questions that have not been posted. With that, let's get started. I just want to make sure you guys can hear me. 1 second.
The conference is now in conversation mode.
Can you all hear me okay, folks? Can you hear me?
Yes.
All right, excellent. Let's go back to the questions.
The conference is now in presentation mode.
So there are a bunch of questions I have marked as frequently asked. The first one amongst them is about PERM Prevailing Wage Determination, how it works. So when you get into the green card process, one of the ways you can get a green card is through PERM. The PERM process is conducted by the US Department of Labor. The employer is supposed to pay for everything. The employee should not have to pay directly or indirectly. So it's entirely the employer's expense. The first step within PERM is to apply for prevailing wage. So we decide what the job is going to be, and we file for a prevailing wage request, which unfortunately is taking 7, 8, 9 months. It used to take 2 or 3 days. Now the question here is this. The person who has posted this question, Vineet Sawant, Vineet says, my company applied for my prevailing wage and it came out to be $123,000, which is about 35% more than what I'm making right now. And my lawyers are not providing me a copy of the prevailing wage. Is this okay? And the answer is yes, because it is the employer's property. Under the Virginia rules of ethics, lawyers have to protect the interest of both clients, no matter who pays their bills. So I would have to probably give you all the information that you need to protect yourself, unless the employer has signed or the employee has signed some kind of a waiver that says you don't expect any documents from your file. So essentially, you actually have, both sides have complete control over the file. Whatever we have as lawyers, we have to give you copies. But different states have different ethical rules. So one of the things you can do is, if you're trying to get a document from your file, you can check with the Bar Council or the Bar, not the Bar Council, the Bar Association, actually the Bar, which is typically governed by the Supreme Court of the state, the highest court of the state, where the lawyer is admitted. You can find out what the rules are. And they're usually very good about talking to members of the general public. So find out, by all means, what you can get and what you cannot get. Although, getting the prevailing wage determination, I'm not sure how that helps you. Your second question is that this is a salary that I'm supposed to get paid when I get my green card. That is correct. Can I somehow negotiate the salary to be right now? And the answer is, that's up to you. But there is no law that requires the employer to pay you right now. It's a future salary. And the third thing is, does the salary that you've gotten, the prevailing wage, does it include the benefits? So in other words, $123,000 includes 401k, medical benefits, leave, etc. No. The 123 is the base salary, which must be paid to you, clear of all the benefits. Okay? So this is the way the prevailing wages work. Now, I want to add a couple of things. often what happens is when you apply for EB2 category, you end up getting level 4 wage, especially in IT jobs. In other jobs, there may be a little bit of leeway, but in IT jobs, because government's great wisdom says that all IT jobs require BS plus 2 years experience, no more. And almost every green card that is filed is for experienced people. So it is very difficult to get anything below level 4 wage. Where do you find out what the wages should be? You go to flcdatacenter.com. FLC as in Foreign Labor Certification. FLC Data Center, and center is spelled the American way, CENTER, not TRE. Okay? So you can check your wages there, but you cannot, it's not a wage that has to be paid to you right now. It is a future wage. If anybody has any question relating to what I just discussed, press *5 on your phone, please. Any follow-up question on this? Press *5. Okay, let's go on to the next frequently asked question. This one is about recapturing H-1B unused time, which is remainder option, changing H-1B field, and USCIS's stand on combining degree and work experience. So first of all, let me answer these questions generically, and then we can take on specifically what has been asked in the question. Generically, you can recapture any unused time on your H-1B, so even if you're outside the United States. So let's say you came to the US, you got H-1B for 2 years, and then you left. Now, you have 4 years remaining on your H-1B. The question is, do you have to go through the lottery again? And that's where the idea of remainder option comes. The remainder option policy of the USCIS says, if you want to be exempt from the lottery, then you have to be content with the time remaining on your H-1B. Because if you've been outside USA for a year, you can actually get H-1B for 6 more years. But then you have to go through the lottery. So remainder option says, I will take my remainder. I don't want 6 years of H-1B, and I don't want to go through the lottery again. Okay. Then comes changing H-1B field. So this has been asked many times and answered many times too in our frequently asked questions. If you by degree or education plus experience mixture qualify for 2 different jobs, you can change your fields and you still have the remainder option and you still get all the benefits. So for example, I always give my own example. My first degree is in biology and chemistry, and my subsequent degrees are in law. So I could potentially get an H-1B both as a biologist or as a lawyer. So that is how it works. You can be qualified for more than one field. And how do they combine degree and work experience? Now remember, the rules for green card and the rule for H-1B are different. In the H-1B context, 3 years of experience equals 1 year of college. So let's say you have a 3-year degree from India in mathematics and you have 3 years experience as an actuary or as a mathematician. So we'll take those 3 years of experience, combine it with 3 years of your college, and that becomes US equivalent to a 4-year degree. So 3:1 rule. Now let's see what the questions are. First question is, as a follow-up on the remainder option, what is the time limit where you can remain outside and still recapture the remaining years? There is no time limit on this. So even if you were outside for 10 years, you could still come under remainder option so far. Tomorrow, I don't know what the laws are going to be, but today that's how it is. Yeah, so you should be able to use remainder option. You've been outside for 2 years, absolutely no problem. Then you did your master's in chemical engineering. Your H-1B was issued in 2019. I was told that H-1B could only be used to work in the same field You could always have changed professions as long as you have a degree in the right field. But if you have a degree only in chemical engineering, you have to stick with your own field. But let's say your first H-1B was in chemical engineering, but let's say your bachelor's degree is in chemistry. You could go in with a major of chemistry. Yeah, different profession doesn't mean you don't have to qualify for it. You must be qualified for that profession, and remember, each profession must require a bachelor's degree in that particular discipline. So if you have multiple degrees, so let's say you have a bachelor's degree in, let's go with chemistry, and then you have a master's degree in chemical engineering, then you did a master's degree in information systems, you can go under information systems, chemistry, chemical engineering, because you qualify for all of them. But could you go in as a mathematician? No, because you don't have that degree. Okay? Star 5, this is from Anusha. Star 5, if you have any follow-up questions on what I just discussed, press star 5 if you have a follow-up question. Okay, let's go on to the next frequently asked questions. H-4 EAD visa holders opening an LLC in the US and employing their H-1B holding spouse on concurrent H-1B. Sure, why not? Let's say that I'm working in the United States for IBM. My wife got her H-4 EAD. She started a company, and let's say I'm a software developer, and she got me a project as a software developer. Can I concurrently work for my wife's company? Absolutely. She has to process an H-1B for me, a concurrent H-1B, but I can definitely do that. Nothing stops me from doing it. Are there any dangers associated with it? Just make sure you are meticulously truthful. As long as you are truthful with the government, maximum they can say is case denied. They cannot harm you in any way. Press star 5 if you have a follow-up question on what I just talked about. Star 5 on your phone. Okay. Oh, there is a question. Let's see. This is from California. California, I can hear you. Go ahead, please.
Hi, Rajiv ji. This is Rajesh.
Yes.
So
Rajesh.
you're saying that, if she opens LLC, she can still file a concurrent H-1B. So will that require a lottery or no? It's a direct application.
No. Concurrent H-1Bs are not subject to the lottery. If your first H-1B was, well, actually, let me rephrase that. Concurrent H-1Bs do not require lottery again.
Okay. Sounds good. Okay. So she can employ me, right?
She can employ you.
Okay.
So she'll be the boss of you inside and outside the house.
Is there a chance or any danger in the future? No.
No, I already said
they can
that.
maximum deny the case.
As long as you are truthful,
Okay.
there is zero danger. All of this is perfectly legal, okay?
Okay. Thank you so much.
You're welcome, sir. Good luck.
And if you need a consultation, we can set up an appointment.
Of course, you can go to, you can just send me an email to help@immigration.com. Put down your questions so I can assess the time and cost, and our office will reach out to you and set up a time. Okay?
Even with the filing of the
Of course.
concurrent H-1?
Of course. We do it all the time. No problem.
Okay, great.
Good luck.
Thank you so much.
You're welcome.
Thank you. Have a good day.
You too, sir. All right. So then let's go on to the next question. What if there's a gap in status? For example, H-1B and H-4 status issues. So there's a gap between my H-1B start date, which is April 29th, and my H-4 receipt date, which is May 17th. Can the USCIS deny our case? Okay. I'm not sure I understand this question. Let's try it again. I was on F1, spouse on F2. H-1B was approved 2020 for client A, but change of status was denied. So I continued in my F1 status. Later I moved to client B. Employer filed an H-1B amendment, got the complete approval with I-94, effective 29th April. After approval, we filed I-539 for my spouse's change of status from F2 to H4 with a receipt date of 17th May. Okay, so what you're concerned about is that your H-1B got approved and her H-4 was filed a few days later, right? Because she couldn't be on F2 any longer. So could this be an issue? Technically, yes. This can be an issue. Let me explain to you a couple of issues with gaps in status. So sometimes what happens is that, let's say you are in the last week of your H-1B and you apply for an H-1B transfer with extension with another employer. Okay. Now, when the H-1B gets approved, it will be effective from the date it is approved. So that means there will be a gap in your status technically because your old H1 was over when your new H1 was approved, but that's okay. That's understood to be a part of the process. Your situation is a little different. So the day your H-1B is approved, you're no longer on F1 status. That means your wife is no longer on F2 status. But does she have a 60-day grace period like all F1, F2 people? I think so. So I think what happens is, I haven't thought about this very carefully, but from what I can tell from a snap judgment, even if there were a gap, I think she would have that 60-day grace period. Technically, it could be a problem, but as a practical matter, I would argue that she's got the 60-day grace period. Plus, remember, they're going to send you an RFE. They're not going to just deny your case. Okay? Press *5 if you have a follow-up question. Press *5. All right. Excuse me, guys. Next question. Okay, there are no more frequently asked questions. Really? I thought there were more. Oh yeah, here's another one. Eligibility for EB1A, extraordinary ability. This is question number, I can't tell, 11. So I'm in the third year of H-1B. I've got my, they filed for my green card, my employer in PERM process. I'm a senior energy engineer with industry experience of 5+ years. So then you go on to mention how you meet some of these requirements. And I always tell people, please remember, EB1As are given based upon two-step analysis. First step is quantitative. Do you meet 3 out of 10 requirements? And if you do, then they go to step 2. Does your resume look like you are the top 10% people in the country in your profession? So let me give you an example. Let's say I have only one publication. Technically, I meet the requirement that I have scholarly publications. But when they do a step 2 analysis, they start asking, number one, is this your only publication? Top 10% people have 150 publications, 200 publications. Number 2, how many citations did you receive? Number 3, what was the impact factor of the journal? All of these things go into step 2 analysis. So even if you meet the numbers, you may not meet the step 2 requirements. And that's always difficult to predict. Sometimes cases that look like they're impossible to get processed, it works out. And sometimes the best cases get denied simply because it is the judgment of the officer that you are not the top 10% people. Very difficult to fight with that. Okay. So, for example, you have written that I have been asked to judge I'm currently on the editorial board of an international journal. Now, you know what they'll do on step 2? Step 1, you will pass. Step 2, because you are a peer reviewer, they'll say, tell us that only the top 10% people are hired by this journal or retained by this journal to be editorial members. 2, tell us who are the people who select you? What are their qualifications? Are they themselves top level people? Number 3, tell us what the qualifications of other editors are. How do they get selected? So this gets a lot more complicated than just a matter of numbers. You want me to take a look at your resume, I can take a look at it. you can email it to me at help@immigration.com. I'll set up a call, go over your resume. But remember, there's a two-step analysis here, okay? *5, if you have a follow-up question, guys, *5. Okay, we have a question from Illinois. Illinois, go ahead, please. I can hear you.
Yeah, hello, sir. This was my question again.
Uh-huh.
So with regards to the first question, like lesser internationally known recognized prices, so I've considered like 30 under 30, but again, this was a global award that was I was honored with.
Yeah, hang on.
Can this be considered as an international award?
Hang on. I'm not going to take time from the conference. We can talk separately, you and I. I'll have to look at what the awards ranking, etc. is. But if the award is indeed open to an international set of participants, and the people who give the award are themselves highly qualified people, best qualified almost, and lastly, the people who have received this award in the past are themselves top level people, then that award could qualify. So international participation, selected by highly qualified people. In the past, they have selected only the best qualified people. And yeah, one more thing, what are the criteria for selection? So for example, if the award says you must have 10 years of experience, that's not good enough. We are looking for the top people in the profession. The award cannot be given just because you have some experience. So I can't really discuss it in detail here. Send me your resume, I'll take a look at it. Okay?
Okay, sounds good. Thank you.
All right, sir. Then we come to, here's another one. Filing multiple PERM applications, PERM recruitment period and processing times for prevailing wage determination. So can you file multiple PERM applications? No. You cannot file multiple PERM applications for the same employee for the same job. What if the company has one office in California and one office in Washington, D.C.? Can you file for two different locations? Probably yes, because it's not the same job. So you can't apply for the same job, same location, etc. So the first question here is, can we file two PERM simultaneously, one for the current job and one for the future promoted level? You know, what will happen is, technically you could, but what will happen is, because it's not the same job, you will get a rejection in either one or both of the PERM, and then you'll have to file a motion to reopen. That could take several months, and justify why these are two different jobs. So technically you can apply for two jobs like this because they're two different jobs. My employer filed my green card based upon masters with no experience. What are the chances I'll pass recruitment during PERM, keeping current recession in mind? Well, that depends upon the job. So for example, if you have a master's degree, the requirement is a master's degree in, let me take an example, robotics, okay? It might be difficult to find people in robotics. I don't know what the requirements are. So definitely, when there are experience requirements, specific skill requirements, the chances of success are a lot better. My employer told me prevailing wage and labor set will take 12 months each. No, not 12 months each, but closer to 7-8 months each. That's what it has been. Okay, I don't think they are being slow in the process. The process itself is slow. *5, if you have a follow-up question on this, press *5. Okay, let's see. Doesn't look like there are any more frequently asked questions. Now let's go into the regular questions, and if time remains, then I'll answer new questions. This we answered, this we answered, this we answered. Wow. So Karma Yogi, USCIS typographical error. So this is a company who wants to know what should we do. There's a typo, and when we try to correct it online, the data fields don't match what we need to fill. So in that case, what you should do is you should just pick up the phone and call the USCIS customer service. Okay. I looked at those fields, by the way, for another client, and I think what we decided to do was put down the name of the beneficiary where it asks for the first name and the second name of the petitioner, and when it gives the receipt number, that should straighten out. But I think the best option is to just call USCIS customer service. Okay. *5 if you have a follow-up question. Press *5. One advantage of filing premium processing is that if this case was premium, you could have just emailed or called the premium processing service. They would have taken care of it. Okay. Any follow-up questions on this, guys? Next question. Visa wait times and eligibility for interview waiver. Working in Canada on dependent visa with open work permit and applied for tourist visa to return to India. Okay, I'm not sure what this is. I was in the US on L2 with EAD until April this year. Worked for multiple employers during the last 7 years. I moved to Canada on a work visa and work for a US based company in Canada. They have a branch here. Okay. I need to visit them quarterly for business related meetings. I applied for B1, B2, so coming from Canada to USA. There is no slot available. Based upon interview waiver announced earlier, am I not eligible to take advantage of that? You should be. I don't know what the Canadian interview waiver policy is. I think it is the same all over the world, but you can double check. The interview waiver says if you are applying from your country of residence, you are, it's Canada. 2, you've been given a visa in any category, you have L2 visa. Number 3, you have never been denied a visa that was not subsequently overcome. So even if you got denied, then you got granted, you are eligible for interview waiver. Okay. Now, does the interview waiver apply to all cases? It does not. They had done it mostly for student and H1, L1 type visas. Does it apply to B1, B2? I know that US consulates in India are applying it, but you'll have to check with check the the US consulate's website in Canada. That should tell you what their policy is. Okay. Yeah. So for interview waiver, the visa category in which you are applying and which you had before doesn't have to be the same. Press *5 if you have a follow-up question on this. Press *5. Okay. Then EB1C Green Card Eligibility. I have a question about Green Card Eligibility. I have a Bachelor of Engineering Mechanical in India. Worked at company A for 2 years. F1 visa 2013 to 2015. H1B with a US company. Moved back to India during the month of October. Worked with company A from 2018 to 2022 as a manager in India. F1 visa, August till date. Job offered from company B, which is a subsidiary with company A. You should be eligible for EB1C because remember, to qualify for EB1C, you should have worked for the company abroad for 1 year out of the last 3. You qualify for that. And the company in USA must be related to that company and also offer you a managerial or executive level job. So it looks to me that you could qualify. Yeah, I've answered all your questions. Press *5 if you have a follow-up question. Press *5. Okay, this one is from area code 316, Kansas. Yeah, Kansas, go ahead, please.
Yes, this is actually my question. Thank you for taking
Of
the time
course.
for arranging this call.
My
so
pleasure.
I just have one question. If I do F1 CPT with company B, which is a subsidiary of company A, will that not be a problem, right? In the interim, I can do anything I want.
Yeah, you should start your EB1C quickly, but you can join them on curricular practical training. Why not? Absolutely. Okay.
Because it's a one level high. I'm doing CPT at the PhD level. So
I don't see, as long as your DSO is okay with the job, I don't see why not.
yeah.
Okay.
Okay, just one more follow-up question. So the parent company, I didn't plan for this to happen. It just happened organically. My job offer with company B, which is a one of the subsidiaries of company A. But
Okay.
so I was a functional manager. Like I saw one of your heard one of your recordings that a cost
Yeah.
controller.
Could you hold on 1 second?
Expert.
Hang on,
I was,
sir.
a corrosion
1
specialist.
second. 1 second. I have to lock the conference. Give me 1 second. Because I'm not going to be able to take unlimited questions. I just want to make sure people who are here, I attend to them.
The conference is now locked.
Okay. So yeah, you were a functional manager and you heard what I had to say about that. Go ahead, please.
Yes. So, what are the documents would be needed for that? Just the job description with percentage of time allocated for the duties is enough, or what kind of evidence you would
So
need
basically,
from the parent company in India?
they can ask for more than just a letter. They can ask for samples of your work, what you did. For example, if you prepared a project report, copies of something like that. So they can ask for further evidence, but we begin with letters usually. Okay?
Okay. So, I mean, how do I access that? Because, this is a totally different. I left without, thinking that I'll be.
Yeah, but these are related. These are related companies, right? They are related to each other.
Yes.
So yeah, as long as they are related, you can approach them through your channels and ask them to provide the information. It shouldn't be that difficult. Okay.
Okay.
Good luck, sir.
Thank you.
You're welcome. Bye-bye. So let's see. Area code 832 has a question from Texas. Area code 832, go ahead, please. I can hear you.
Sir, my question is about EB1C.
Uh-huh.
Is there any timeline to join the company when your EAD is approved?
Is there a timeline to join the company when your EAD is approved? So what happens is, let's say that you took a break from those companies and you are working for some other company totally, and your green card is being applied by the old company. And first of all, you don't have to join them until a reasonable period after the green card approval. So I would assume, there's no law on this, 3-4 months after your green card gets approved, you should join them.
EAD approval 3-4 months, sir.
No, I didn't say EAD approval. I said
green card has not yet been approved.
So, ma'am, you didn't hear me. So. Your question to me was, when do I have to join them? And the answer is, within a reasonable period after your green card is approved. Did you forget your own question? You asked me, when do I have to join? That's what I answered. Okay. It looks like your male...
If I enroll for...
Your male friend has a question. He can ask me. I heard somebody talking with you.
No, not exactly.
Achha. Okay.
Yeah.
All right. You're all set?
Can I enroll for health insurance, sir? Will that be considered as a health benefit from government?
No. Health insurance, while, if you purchase health insurance... No, ma'am. That's not a problem. Okay.
Like there's a new initiative, healthcare.gov is offering, and
yeah, I don't see any problem with that. I'm not aware of any issue with that. Okay.
Okay, that's not considered as any government benefit.
I've answered the same question 3 different ways, ma'am. Okay.
Thank you, sir.
You're welcome.
Thank you.
Bye. All right. So then comes the next question is number 9. Parents with EB2 and EB3 approved petition, can one request USCIS to process son's application in EB3 by submitting a relinking letter? I've never heard of relinking letter, but okay, maybe that is a thing. So the file was separated. As a family, we had filed I-485, I-140 concurrently in EB3, downgrading. Our downgraded petition was approved, but our dates became current only in EB2 and retrogressed in EB3. So you transferred the underlying basis. My spouse and my application were approved, but my son's application has been separated and still pending. So it will be processed under EB2 because that's what you requested, hopefully, for everyone. Priority date is now retrogressed and became current. Now, I don't think you can change it back. No, sir. I don't think you can change it back. I don't see how, because your EB2 green card is already approved. And he has to wait till the EB2 dates become current. I don't see what else you can do. Star 5, if you have a follow-up question on this, star 5. You see, as long as he has his 485 pending, what is the problem, right? He can keep going to school, keep working, whatever he wants. So don't be anxious. I think he'll be okay. Star 5, if you have a follow-up question on this, star 5. Okay. Next question, number 10 is, this is L1A to H1B change of status. I'm in India. Company A filed for H1B in 2022 cap. My current company applied for L1A visa. Both are approved. Can I stamp both H1B and L1A petitions separately? Can you? Yes. Will you be allowed to enter on both? No. You have to pick one or the other. And the consulate may even refuse to stamp the second one. Can I enter the USA by using L1A visa? If you're going to work for that job, sure. After some months, can I apply for change of status? Yes. From L1A to H1B, sure. Ideally, I'm trying to travel by using L1A and later can I apply for a change of status? Yes, absolutely. I don't see any problem with that. So if you get an L1A stamped, you come in. I would not do an H1B. Come in on an L1A stamp, work for the L1A company for a few months, and then convert to H1B. I don't see any problem with any of that. Star 5, if you have a follow-up question on this, press star 5. Okay. Let's see. Oh, there is a follow-up question. 1 second. Let me go back up. And this looks like a foreign number. I can hear you. Go ahead, please.
Yeah, sir. Hi, sir. I am Muthu.
Yes, sir.
So I can stamp both the petition.
No, hang on. Stop. Do not try to stamp both. If you are coming on L1A, come on L1A visa. Come here, work, and then apply for a change of status to H1B. That's perfectly fine. Okay?
Okay, sir. Okay, sir.
Good luck. Okay. Then we go on to, let's see. Question number 12. Can one work using the H-4 EAD receipt? I'm from Atlanta on H-1B, applied for wife's EAD. It is approved, but since my H-1B was valid until October, she could not start the job in time. Now my H-1 and H-4 extended till March 2025. I've applied for renewal. Can she start working on receipt of EAD extension? No. She cannot. Now there is an automatic extension for up to 500 plus days, but that only exists if your I-94 is also valid for that same time. So if you have time remaining on your I-94 10 days and you file for the extension, your grace period to continue working is only 10 days. Okay. And you can't work on receipt once your EAD has expired and you are not covered by the I-94 provision. Okay, you cannot. You can try expediting the H-4 EAD by making a request to the USCIS demonstrating what the need to expedite is. Okay. *5 if you have a follow-up question. Okay, let's go to, anyone know why the DOL website has not updated the PERM section yet? No idea. The processing times, right? And then it looks like the last question, after which we'll deal with new questions. I'm a 50-year-old naturalized US citizen, care for my intellectually disabled Down syndrome brother, living with me for the last 13 years. He's non-communicative, needs help with everything. He has an I-130 approved family immigration. Yeah, but see, he's been unlawfully present. So I don't know how you can get adjustment of status for him. I do not know of any way to get an adjustment of status. I don't see how he can. I really don't. Okay. Somebody raised a hand, area code 508, which is Massachusetts. All right. Yeah, go ahead, please. Massachusetts, I can hear.
Yeah, that's Meena. Yeah. So, can I not do a waiver of inadmissibility?
You'll have to talk with somebody who does these cases. We deal with employment-based cases. Waiver of inadmissibility is available in very limited grounds. I'm trying to remember, we've done a few of these waivers. I am trying to remember the waiver for unlawful presence is available only. Let me double check the law. Give me 1 second. Immediate family members, exceptional hardship, something like that. Let me tell you exactly what the waiver requires, but you can check with another lawyer. Unlawful presence waiver. So, non-citizens who are not eligible to adjust their status must travel abroad. Individuals who have accrued more than 180 days of unlawful presence must obtain a waiver of inadmissibility under 212A9B. The provisional unlawful waiver allows these individuals who are eligible for immigrant visa, who may need only a waiver for the unlawful presence to apply for that waiver. So what they are saying is, I think this has a name, I forgot what the name is. I'm looking at the USCIS website. They are talking about the provisional unlawful presence waiver process allows individuals who are in the United States to obtain a waiver before they depart. So you can actually apply for his waiver. He still has to go outside USA. Okay. So even with a waiver, he has to go outside USA. So eligibility requirements.
And with the waiver, then with the waiver, then we have to renew his Indian passport. That will be renewed based on the waiver.
I don't know what the Indian rules are, but you know what you can do? Just Google search for what I did. Just Google search for provisional unlawful presence waiver. And I don't see how you would get, because I'm looking at the waiver requirements, immigrant visa, be able to demonstrate that refusal of your admission to the United States will cause extreme hardship to your US citizen or legal permanent resident, spouse or parent. You are not his spouse, you are not his parent. I don't understand how you would get this waiver.
Yeah, I'm his guardian, right?
Yeah. But that's not a parent.
He's 48 years old.
No, that's not a parent.
Okay.
I don't see how you would
get... Will a conservatorship help?
Sorry?
If I do a conservatorship for him.
No, but you still don't become his parent. No matter what you do. You don't become his parent.
Okay.
Now, there is one
So
option.
there is no recourse here.
No, there is one option, and I don't think it is possible, even though it is in the books. You can Google something called Immigration Private Bill. So Google those words, Immigration Private Bill. Sometimes in very
Okay,
difficult.
that is by a senator, right? The senator
Exactly.
has to.
Exactly. A member of Congress passes a special law for your brother to get green card.
That is a very, very
Rarely
outlier
done.
case. Okay.
Rarely done, but that's the only thing I can think of. Because even if you apply for a waiver, you have no capacity to ask for a waiver because you are not spouse or parent. And even if he got the waiver, he would still have to go outside USA for visa stamping. Okay.
Oh,
So
all right. Okay.
good luck, man.
Thank you.
You're
Thank
welcome. You're welcome. Somebody raised their hand from Dayton, Ohio. Yeah, Ohio, I can hear you. Ohio.
Hi, sir. So I have a question related my sister file I-130 for my parents.
Okay, 1 second. 1 second.
So
Hang on. I'm going to put you on hold. Let me ask for people to raise their hands. I'll take everybody's questions in turn. So whoever has signed in first will get their first bid. Let's see how many questions there are, and I'll make sure I answer your question. Stand by. Anybody who has any question, please raise your hand. Press star 5. Anybody who has any question, press star 5. Oh, wow. You are the only one. Excellent. So talk about, though there are more people. All right, I'll answer your question first because I already started. Okay, so you have an I-130 pending. What were you saying? Go ahead, please.
yes, my sister filed for my parents
Uh-huh.
I-130, and we only received for my father and to pay the fees and submit the sponsorship document. And it has been approved too.
Right.
But we haven't heard anything for my mother. So I'm not sure. I tried to call a couple of times, but they just, give me the same information that is presented on website, and it is automated. No one ever talked to me yet. So
You
I don't
can
know what from this one I can do.
you can contact your congressman's office, sir. Okay. Contact your congressman, either the senator or the member of House, and talk to them and say, I need help with immigration. They will reach out to NVC and take care of it for you.
Due to them.
They're very good at it.
Okay.
All right. Good luck.
Okay.
All
And
right. Uh-huh.
thank you.
You're
I
welcome.
had one follow-up question too.
Uh-huh. Sure.
So my sister filed a immigration visa for me too. And I'm here in US on F1 OPT.
Uh-huh.
So I'm not sure if that
Well,
there is a way I can
no, that's not going to help
file
you.
any
That's not going to help you. Sister's petition will take 14-15 years to come through. And during that time, you cannot stay in the United States. You have to figure out your own path. So you'll go to H-1B. You can also apply for a green card through employment. Sister's green card is way in the future. Okay?
Okay.
Good
Thank
luck.
you.
You're welcome.
Have a good day.
You too, sir. Okay. Now I have only two more questions. One from Texas and one from New Jersey. Texas logged in first. Let's go to Texas. Texas, go ahead, please. Texas. Hello.
Sorry, sir, I was on mute.
Okay, go ahead, please.
Sir, I'd like to detail the questions I asked earlier. It is my startup that filed I-140 for me,
Your
and I got
startup.
my EAD. So, is there any timeline? Will there be any implications or timeline for the company to hire me?
The answer remains the same, what I gave you earlier. Although I must say you got an EB1C, right?
Yes, sir.
Yeah. So you have to join the company within a reasonable period of time after you get your green card approval. Same answer. Okay.
Actually, there was an error on USCIS part. I got my EAD on July 23rd, and on July 29th, the online status said that appeal denied.
Ma'am, I have no idea
And
what your...
I had to go back to
Hang on. I have no idea what your case is. Let me deal with the other question first, because they have been waiting to. Just let me get... You have already talked to me. So, New Jersey, I can hear you. New Jersey.
Hello, sir.
Hello, ma'am.
Sir, we are here on my spouse is on L1A visa.
Mm-hmm.
So now, last year, his employer had applied for his I-140.
Mm-hmm.
His category falls in the EB1C category.
Right.
So unfortunately, we got a denial last year, telling that the task distribution and the manager skills were not proved correctly.
All right.
So our L1 visa will get extended and renewed successfully without any problem, and the same thing will be submitting for the I-140 as well. Just that few of the tasks were modified by some his office personnel, which being the main reason. So my question is, so if we reapply again, so what is the best duration of gap that we have to give, and how should we put up the reapplication?
But that's a lawyer's job, not your job. Your lawyer should tell you how to present your case. It has to be presented truthfully. It should have a truthful explanation of any discrepancies. You don't have to wait. You can apply right away. You can apply again right away. No problem. So there's no cooling off period. You can apply right away. All right. Anything else?
Okay. So and how that the reapplication will be considered? Like seeing the denial notice, how would they feel that it would be genuine submitting it again?
I can't answer that question because I don't know the facts of your case. But if there are discrepancies, they have to be explained. Why is there a discrepancy between your L1 and EB1C? So as long as you have a truthful, genuine explanation, you should be okay. All right.
Okay.
Okay,
sir. Thank you.
Good luck, ma'am. Okay, now
Thank you.
let's go back to your case, Texas. So you were saying appeal was denied, EAD was granted. I don't know what's going on here.
Yeah, that is a USCIS error, sir. And yesterday I got an update from the office saying that actually the background check is going on and that it is not denied. And the appeal, we never appealed it. It is an application for I-140, right? So they clarified the status yesterday.
Okay.
So does the reasonable period start from yesterday or it starts from July 29th?
But your green card is not yet approved. Only your I-140 is approved, yeah? Right? Or is your 485 also approved?
485 not yet approved. So
Until the 485 is approved, your green card is not approved.
Yes, sir.
I have answered your question. When does the reasonable...
I got the point.
Yeah. So, but I'm concerned about your case. I don't know exactly what's going on. You have a lawyer representing you, right?
Not exactly, sir, because it's my startup and
you should
applied for it, taking a consultation.
Make sure you have a lawyer review your case. I'm a little concerned. I don't know what's going on here. So have your lawyers review your case. Make sure that everything is in order. But if everything else was okay in order, I would not worry about having to join the company until 485 is approved, because that's when the green card is approved. Okay?
Meanwhile, can I work for other companies, sir? Because
I would be very reluctant to do that. Why would you not work for your own company if you're working? So I'm a little concerned about you. That's why I said have a lawyer, talk to a lawyer. This doesn't sound right to me. Something is not right here. Okay?
Okay, sir.
Good
Thank
luck.
you. Thank
Good
you.
luck.
Appreciate
Yeah.
it.
Okay, so there are no more questions, folks. Always a pleasure to talk to you all. Take good care. I'll see you in 2 weeks. Bye-bye.